Well, good afternoon. It's noon on Tuesday, and that means it's time for another session of Your Estate Planning Questions Answered, brought to you by the attorneys of the Trust, Estate, and Elder Law Group at the Van Winkle Law Firm. I'm Heather Goldstein. This is my partner, Steve Grabenstein. And for the next 30 minutes, we are going to talk to you about court-ordered guardianship and alternatives to guardianship. Before we get to that, a couple of reminders. This is session number 9 of 16 in the series. We are on every Tuesday and Thursday from 12 to 12:30, Facebook Live at the Van Winkle Law Firm Facebook page. So we hope you'll tune in. And all of the prior sessions that you have missed are still available for video replay. So you can go back and look at any of them as many times as you would like to. We know that we have friends who are joining us from all over the country, but we should clarify that this discussion is principally confined to North Carolina law, which is the bulk of our practice. Our attorneys are licensed in other jurisdictions and we do practice in other states, but for purposes of this discussion, we're mostly focused on North Carolina law. And we do want you to know that this talk is based on our experience with clients and the questions that they most frequently ask us. But if you need legal advice, your situation is unique and you should find an attorney to meet with and get some advice specific to your situation. Please don't rely on this presentation. With that, let me turn it over to Steve to introduce our topic today and talk to us about guardianship.
Thanks, Heather. Good seeing you again. Nothing I'd rather be doing at lunch on a Tuesday than our presentations, or on a Thursday. I think I've got a couple of more of these coming up, and I'm looking forward to doing those. So today we're talking about guardianships, and we'll also talk a little bit about alternatives to guardianships. You know, there's a couple of situations, fact patterns that are just sort of customary that we see in guardianship proceedings. And I think the most, what I'll call the classic scenario is mom or dad is getting up in years. Maybe they've had some dementia, maybe it's been modest dementia, but it's starting to advance. And family members, loved ones are clearly seeing that mom or dad is just no longer capable of making sound decisions regarding healthcare or finances, or perhaps both. And they're wondering, what can I do to protect my parent in this situation? So I tend to look at that as sort of the classic, and then sometimes the most easy situation to deal with when talking about guardianships. But guardianships also come into play sometimes when you're dealing with minor children. And folks may not have that bubble up in their minds, but you know, you might have a situation where you've got a child with either psychological challenges, mental challenges, or other types of challenges or disabilities, and they might need the extra layer of protection that can be provided through a guardianship for a minor. And then there's a pretty narrow subset of cases that I know I've been involved in, and I think you have as well, Heather, where you're dealing with individuals who have substance abuse issues, whether that be alcohol or drugs. A guardianship is a tool that might, and I would underscore might when dealing with substance abuse issues, might come into play. So that's kind of a classic overview of the type of situations where folks might think about having a guardianship. And then the question becomes, all right, I've got that kind of situation. What do I do other than talking with a lawyer at the Van Winkle Law Firm about it? What's the next step?
Well, you know, so I wanted to add a couple thoughts to some of what you were just saying there before we move on to the next step. And guardianship, in case you're watching and you don't actually know what that is, I think it warrants sort of framing this as it's a process of going to court and having the court assign a person or persons who will take over all facets of decision-making for another person. That could be healthcare decision-making, legal, financial, and personal, depending on the situation. So it is essentially a process of removing a person's right to make their own decisions and vesting that through a court order in another person. Guardianships for minors don't come up quite as frequently, but I thought I would add to what Steve said about that. The only time you can get a guardianship for someone who's under the age of 18 is when both parents are deceased. If there is a living parent, even if that parent does not have custody, jurisdiction for that child is before the district court in family court. And so if you have a living parent and there is an argument or a resolution needed on who will care for the child, that's really a custody proceeding in district court. So you get to guardianship when both parents are deceased. And you should know that parents, when they're planning for their minor children, can nominate in their wills who they would like to be considered for guardianship for their minor children in the event that both of them were to die. And the court will give some strong consideration to that nomination by the parent. The other thing you might want to know about is standby guardianship, which I could see being most appropriate if you were a single parent and diagnosed with an illness that you thought would be terminal and you have minor children. So you expect that you may not live to their majority. You can go through a process of standby guardianship, which allows you to participate in the court proceeding while you're still alive and have a guardian put in place that will come into effect immediately upon your passing. So that's another planning tool for parents with minors. But it's true, as Steve said, that most of our work in this area is with either older adults who are losing cognitive ability due to aging or a disease such as Alzheimer's or Parkinson's, a degenerative type of disease, excuse me, or adults that have had some kind of physical or cognitive impairment, perhaps their whole life, and are going to need assistance when they reach the age of majority. And so in those situations, we have to go to court. Well, I'll say one more thing, and then I'll probably let Steve describe the court process for you. The next threshold issue is why are we going to court? Because there are the fact pattern that gets us there is common. And first and foremost, it has to do with the person for whom guardianship is sought does not have any of their own legal documents that would allow them to delegate decision making. So you may have heard of power of attorney documents, and many adults have those. But if you don't have those and you become or are incapacitated, then someone is likely to be in court trying to have a guardian appointed for you. Or it could be that you had documents and those documents aren't working for you. And that could be because family members are fighting for control. You may have children or other members of your family that have been appointed under your documents to work together and they can't, or they disagree about decisions that should be made for the older person. Or it could be because the older person is putting him or herself at risk by their own behavior, either through we see this with substance abuse, making choices about substance abuse in a way that's dangerous for them, or spending their own money in ways that are risky, financially risky for them. And just because someone has power of attorney for you doesn't mean that they can stop you from doing that. And so we're looking at guardianship to stop you from being a danger to yourself in those situations. So that's kind of how we get there. And when we get there, we have to initiate a formal court process. And this is what it looks like.
Yeah, and it's a good point to remember that a guardianship is a removal of an individual's rights. It's a very serious proceeding. And one of your threshold determinations is in what realm do do you need to take that step? Where does the person need protection? Are they unable to take care of financial matters, but able to get by in other aspects of their life? And the reason this is significant is that the courts in North Carolina recognize three different types of guardianship, and you sort of need to make this determination at the front end. There is a guardian of the person, and that is somebody who will help. I always shorthand that on the healthcare side of things with the personal decisions, that an individual is no longer able to manage those issues for themselves. That's one type of guardian. Another type is a guardian of the estate. That is an individual who's appointed solely to handle financial matters, fiscal matters. And it could be that you've got problems in one area, but not the other. So you might make the determination only to seek a guardian of one type or the other. You can ask to have a general guardian appointed, and the general guardian encompasses both the guardian of the estate and guardian of the person. So once you make that determination, the process gets underway by the filing of a petition. The petition can be filed by really anybody who's got an interest or knows of a situation where a guardianship they believe is warranted, has standing to file a petition. The petition, one of the aspects of a guardianship proceeding that I tell all prospective clients is that the petition has to be served on the alleged incompetent. And that typically means you're sending the sheriff's department to mom or dad's house or to the nursing home or wherever they may be with that petition. I emphasize that at the front end because that is a bit unsettling to folks, that I want to help mom and dad, but I don't want them to think I'm suing them. And sometimes folks have retained enough capacity to understand there's a sheriff's deputy in my room and they're handing me papers that my son or daughter has filed with the court saying that I'm incompetent. So that's something that you got to walk through at the front end. You also have to give notice of this proceeding to other family members, and it's a little bit unclear who else you have to notify. And that's a process that you can walk through in terms of, maybe mom has a romantic interest that they've been involved with for a number of years. Not family, but certainly somebody that's interested in a proceeding on competency. So you can get some guidance oftentimes with your clerk of court about who you do or do not need to include in the circle of individuals that have to be involved in this proceeding. There's one other person that will be involved in the proceeding that gets appointed by the clerk's office, and this proceeding is before the clerk of court in North Carolina, in whatever county you're in. And the clerk's going to appoint a guardian ad litem. And maybe, Heather, that'll be a good time to ping the ball back over to you to talk a little bit about what is it that a guardian ad litem does, and if a guardian ad litem is appointed in a case, what happens if the alleged incompetent says, I'm going to go hire my own attorney?
I'll be happy to take that ping. Those are two good questions. First of all, the terminology that we use can be confusing when we talk about someone who's been appointed to be a guardian ad litem. That is not the same thing as the guardian that we are seeking to have appointed for the person who is the subject of this petition. Guardian ad litem has a limited role that is twofold. On one hand, they are there to be the advocate for the respondent. That's what we call the person who is the subject of the incompetency and guardianship petition. They are the respondent, and the guardian ad litem is their advocate. So the guardian ad litem will meet with them will determine if they have particular wishes or desires about how this proceeding will go. And sometimes respondents have opinions about who should serve as their guardian. Sometimes they have opinions about whether or not they should be declared incompetent. And it is the job of the guardian ad litem to convey the respondent's wishes and desires to the court. And so they will prepare a written report and most often will offer testimony at a hearing to be sure that the respondent's wishes have been communicated. But they also have a job which is a little bit more neutral, to present a third party opinion to the court. And so the guardian ad litem, in doing their work, is usually going to conduct interviews with whoever is the petitioner and any other significant family members or interested parties in order to determine the extent of the potential incompetency and the suitability of the individual who has proposed themselves as guardian. Or in some cases, you have more than one individual proposing themselves, and there's actually a dispute about who should serve, and the guardian is going to reach an opinion about what is in the best interests of the respondent. So they are also fact gathering and looking at all of the evidence and making a recommendation for the court. Now, the respondent has a right to an attorney, and all they have to do is ask for one and the court will appoint one for them. And you do have some interesting dynamics when the respondent has an attorney. The court still has the option of having a guardian ad litem, and in many cases will still have a guardian ad litem, even though the respondent is actually represented by counsel. In those situations, the role of the guardian ad litem changes to exclusively this third party information gathering, and they do not play the role of advocate for a respondent when there is counsel. One other thing I was thinking about as I was talking about the guardian ad litem looking into the extent of the incompetency that we haven't talked about is that when so a guardianship proceeding is really a two-part proceeding when you're talking about adults, not minors. But with adults, the first part is this individual incompetent? And the legal definition of incompetency is unable to make or communicate important decisions or manage their own affairs. And so that is one legal question that has to be answered, is whether the person is incompetent. If they are incompetent, then the court must appoint a guardian for them. And the secondary inquiry is who is an appropriate and qualified person to serve. But on the incompetency question, it's not an all or nothing. There is a notion of limited guardianship, which comes up in situations where the court decides that an individual can retain certain spheres of decision-making for themselves, but maybe not others. And in that case, you are going to have a limited guardianship. I don't know, Steve, if you can think off the top of your head types of situations you've had that are good examples of where a limited guardianship has been appropriate.
Yeah, you might have an individual who can't manage large sums of money, but they're certainly capable of managing, say, a couple $100 or up to $1,000. So you don't want to take away all of individual's financial freedom. So the clerk would be free to say, if the individual is going to be deemed incompetent, I'm going to allow them to retain a bank account up to a certain level. And why might you do that? Well, you want to encourage the person, maybe they have a job. You want to keep them out in society and active as much as you can. So that is certainly an instance where some rights that an individual has are protected and preserved. And I think that's a very positive development, at least that I've seen over the last, I'd say, 5 or so years, where the clerks are paying greater attention to a laundry list of rights and responsibilities that an individual has, and seriously considering maybe I don't take this one away, maybe I limit this one to some extent, but not completely, which I think is great because again, you're deemed incompetent, you're losing a lot of rights, which is why the threshold, the evidentiary threshold in a guardianship proceeding is as high as it is. You know, we're accustomed to the old scales of justice and it just being tipped a little bit for one side to win. In a guardianship proceeding, it's a preponderance of the evidence standard. So the scales have to really be showing that the individual is in fact incompetent. There cannot be any question about that. And again, in the classic case, if you've got your medical proof of an advanced cognitive impairment, that's not going to be an issue. And to your point, Heather, many times the parties will come into this type of proceeding with the family in agreement on the fact that the respondent is in fact incompetent, and the dispute is who gets to serve as the guardian. And we've seen a lot of good wrestling matches amongst families over that role. In those cases, before we switch topics again, I do want to make note that in the cases where there might be a little bit of a gray area about whether or not the individual is incompetent, the courts allow us to make use of another tool to help make that determination called a multidisciplinary evaluation. That and oftentimes all parties will agree, even if there's a dispute about whether or not the respondent is incompetent, they'll agree we should get an evaluation to help us answer that question. And you file a petition with the court asking for this evaluation, and 9 times out of 10, the court's going to say, yeah, get that evaluation done. So Heather, let's assume that we've gone through the hearing. The respondent is deemed incompetent. That decision has been made. Is that it? I mean, is that the end of the proceeding? Somebody gets appointed. Are they free to just proceed from that point?
Oh, that's a great question. And it's one that in our experience, our clients don't always see very.
I'm going to interrupt you for a moment and point out, at least for me, you're now through, it may be that it's appropriate that it's Halloween. You've got one of those Halloween sound effects going with your voice. So
did that change it at all?
It did.
Okay. I don't know why. I'm sorry, Facebook world. This happens to me every time I get on Zoom, but I'm glad
it was a special effect as we were getting close to the 31st. It was quite chilling.
Good. I should have worn an appropriate costume. And I can still hear you, which is good, Steve. So a lot of people are so focused on the process of getting guardianship that they haven't really thought about the what next. But the what next is actually fairly significant and worth really being sure if you are the person to be named guardian, that it's a task that you're up to. When a guardian is appointed, they have an immediate responsibility. If they have been given guardianship over finances, they have an immediate responsibility to take custody of all of the assets of the ward. And that's the term that we use for an individual who has been declared incompetent as the ward. So that means bank accounts, real estate, retirement or brokerage accounts. You have to go through a process of contacting every third party that is holding assets to get those assets taken out of the ward's name and put into your name as guardian. That does not mean that you can spend or use these assets in any way you wish. You have a fiduciary obligation to use those only in the best interests of the ward. And we do see there are situations where guardians abuse the power that they have been given with regard to assets. And in those cases, they are usually removed by the clerk of court because the clerk of court is carefully supervising the finances and the accountings and the dealings of the guardian. Within 90 days of appointment, you have to file a complete inventory with the clerk of court, disclosing all of the assets that the ward owned on the date of that the guardianship began. And then every year you have to file an annual accounting where you track and provide copies of receipts, invoices, deposits, and checks so that the clerk can see clearly all income and receipts that came into the ward from the beginning of the year to the end of the year, everything you spent and proof that it was a legitimate expense for the ward, and any monies that you've given directly to the ward. The accounting requirements are rather burdensome, and a lot of people find that they need help from a CPA or an attorney to do that, which is one of the disadvantages to guardianship, frankly, that there is some ongoing expense associated with having to do this annual accounting. The guardian also has to be bonded, and there is an annual financial obligation to renew that bond. And there are court costs that have to be paid as a percentage of assets. So from the beginning and always, the court is supervising the actions of the guardians. Another point that should be made about guardians' management of assets is that while you are able to collect income and pay bills on behalf of the ward, there are some things that you can't do without going back to court and asking permission. Examples, the most significant example would be the sale of real estate. You cannot sell a ward's real estate without going to court and asking for permission to sell it. And once you get permission, it's conducted as a court supervised sale, not as a private sale. So the court is really looking for the proper management of real estate. You can't sell personal property that's worth more than $5,000. So a car or any other significant item of value would again require court permission to supervise that sale. You also, if your ward is married or has dependent children, you can't necessarily make distributions to support these family members. And that's a little counterintuitive to people sometimes when the ward was in the habit of supporting these family members. You have to get a court order for how much of the ward's assets can be distributed to spouse or family. And sometimes when a married person goes under guardianship and their spouse, for whatever reason, is not their guardian, you actually have to divide up the couple's assets in a way that sometimes looks more akin to separation or divorce, but that's in order to allow it to be more easily managed by the court and for the non-incompetent spouse to have some assets to support him or herself with. So all of that takes place and more, but we're running out of time. So I will go ahead and move us on and ask Steve to talk to us a little bit about how to avoid this situation, because there are some advanced planning steps that you and family members could take in order to reduce the chances that you would wind up in court with a guardianship.
Yeah, and I think that's a great point to emphasize, that you've just given a wonderful laundry list of work, because a guardianship is work at the front end and at the back end. And as we've said, I think repeatedly throughout this presentation, it also entails the removal of the respondent/ward's rights. So if there are more palatable alternatives, they're often more appealing. They do require thinking in advance, though. You've mentioned one of them, Heather, and that is the power of attorney. Not only just the standard power of attorney, but a healthcare power of attorney, so that the individual who's declining has somebody in place to handle their financial affairs and to get involved in making healthcare decisions. The shortcoming there is the one that you've identified, and that is the power of attorney is great because they're authorized to act, but it doesn't preclude the respondent from acting. The other tool that comes readily to my mind is putting assets in a trust. Again, advanced planning. You deal, I think, a bit more with the drafting of trust documents than I do. I tend to get involved when trusts go off the rails. or need some help getting them back on the rails. So what thoughts do you have about what's appealing about trust or other tools that might help you avoid going down the guardianship path? What alternatives are there?
I think trust planning is very significant for minor children. And I didn't talk about this when we were talking about minors, but another reason that you wind up with guardianship for minors is that they inherit money from someone who has died. And you can't just give money to a minor child. And in many situations, you can't just give it to their parents. There has to be a legal process for ensuring that the money is appropriately managed for that minor child. And you wind up in guardianship if you don't have another option. But a great planning option for anyone who thinks they may leave money to grandchildren or great-grandchildren is to build a trust into your plan so that you leave it to them in trust. Individuals can also do it for themselves through revocable trust, which allows a successor trustee or someone else to take over management of their assets when they become unable to, and to write into the to legislate for yourself the set of circumstances where you would want someone else to take over for you. It can be a little bit stronger than a power of attorney in actually taking away your rights to mismanage your own funds. With that, we're really kind of out of time. So I will, Steve, unless you have any closing thoughts.
Keep talking, Heather. This is great. We could spend all day talking about this.
We certainly could, but we won't. However, if you just can't get enough of Van Winkle Trust and Estate Attorneys, tune back in on Thursday at noon. Our partners, John Kelso and John Veazey, will give you 30 minutes on the topic of tax considerations in estate planning, including estate tax, gift tax, income tax, and capital gains tax. Sounds riveting. You don't want to miss it.
Absolutely.
Thanks for joining us.
Thanks.
Bye.
See ya.